In this lecture, we would like to discuss regarding corporation bill, and as in connection to that, the very important concept of corporation bill is the lifting of the bill of the corporation, and in an English leading case, and that very English important leading case, Solomon versus Solomon and company in 1897, the Court of Appeal held that the corporation in law is equal to a natural person and has a legal entity of its own. The entity of the corporation is entirely separate from that of its shareholders. It bears its own name and has a common seal of its own. Its assets are separate and distinct from those of its members. It can sue and can be sued by exclusively for its own purpose. Its creditors cannot obtain satisfaction from the assets of its members. The liability of the members or shareholders is limited to the capital invested by them. Similarly, the creditors of the members have no right to the assets of the corporation. This petition has been well established. Even after the very decision delivered by the Court of Appeal in this particular important leading case relating to lifting of corporation bill, and that is Solomon versus Solomon and Company in 1897, decided by the Court of Appeal. In regards to that, it particularly announced the legal personality of a corporation. So, in that connection, we would like to discuss another important judgment delivered by an English leading case, that is Lee versus Liz Air Farming Limited in 1961. Also, the judgment delivered by the Court of Appeal, where it was the very fact of the case in order to lift the veil of corporate entity, there must be circumstances to compel the courts to identify a company with its members. The corporate veil is lifted when the court, ignoring the corporate character of the company, concern itself directly with the members or managers of the company, as it was decided by the Court of Appeal in 1961 in this important leading case relating to lifting of corporation bill, and that is Lee versus Lee's Air Farming Limited in 1961. The doctrine of the lifting of the corporation bill has been applied in the words of Professor Palmer in 5 categories of cases, as he pronounced, where companies are in the relationship of holding and subsidiary companies, and that is the first categories of cases where it could be applied, as according to Professor Palmer. And regarding the second one, that as as propounded by Professor Farmer, where a share holder has lost the privilege of limited liability and has become directly liable to certain creditors of the company on the ground that with his knowledge the company continued to carry on business 6 months after the number of its members was reduced below the legal minimum requirement of registration of a company. And so also, in regards to the third important categories of cases as Palmer expressed, the company continued to carry on business, but the number of its members was reduced below the legal maximum, and in certain matters pertaining to the law, taxes, and also due to death duties and stamps, particularly where the question of the controlling interest is an issue. And also, according to Professor Farmer, in the law relating to exchange control and in the law relating to trading with the enemy, where the test of control is adopted. So, almost in regards to lifting corporation bill, as Professor Palmer defined, so the very lifting the bill, why the court, and in that connection we would like to discuss certain developments in regards to lifting the bill by the court in regards to corporation bill, and the first one, determination of character as it was decided in the important leading case, and that is an English important leading case decided in the year 1916, and that is Daimler Company Limited versus Continental Tire and Rubber Company Limited. So, very determination of character as it was decided in this important leading case in 1916 by the Court of Appeal. There may be specific directions of the court to determine the character of a company. As for example, to see whether it bears enemy character or not, as it was decided by the Court of Appeal in 1916 in this important leading case, Daimler Company Limited versus Continental Tire and Rubber Company Limited. And now we'll go to the second circumstance of lifting the will. That is the corporation will by the court, and that is in regards to evasion of income tax. So the court has the power to disregard corporate legal entity and to look to economic realities behind the facet when it is used for tax evasion or to circumvent tax obligations. And now we'll go to the third circumstance of lifting the corporate will by the court, and that is fraud by the company on the shareholder. So the court lifts the corporate will of a corporate entity on the allegation of commission of fraud by the company on the shareholders. And now we want to go to the fourth one, that is criminal liability of corporations. So, a corporation has no animate existence and it acts through its duties constituted duly by human representatives, and the mind of the corporation is the mind of its functionaries. So, these are the very circumstances under which the corporation bill of a corporate house could be lifted by the court. And now we would like to go to discuss lifting of the corporate bill by the legislature. So, in that regard, we would like to discuss three different circumstances reduction of membership, and the second one fraudulent conduct of business, and the third one subsidiary companies. So, the lifting the bill by legislature, apart from the liability of a corporate entity, that the act also imposes personal liability on the directors or members of the company in certain cases. So, those certain cases or circumstances regarding which we would like to discuss lifting of the corporate bill by the legislature, and the first one. And in that connection, we would like to discuss the first cases or circumstances leading to lifting the corporate bill by the legislature, that is, reduction of membership. So, Section 45 of the Companies Act 2013 provides that if at any time the number of members of a company is reduced, in the case of a public company below 7, or in the case of a private company below 2, and the company carries on business for more than 6 months while the number is so reduced, every person who is a member of the company and is cognizant of the fact that it is carrying on business with fewer than 7 members or 2 members, as the case may be, shall be severally liable for the payment of the whole debts of the company contracted during that time and may be severally sued thereafter. And the second cases or circumstances of lifting corporation bill by the legislature is the fraudulent conduct of business as provided under Section 339 of the Companies Act 2013, which provides that if in the course of ending of a company it appears that any business of the company has been carried on with intent to defraud creditors of the company or any other person or any fraudulent purpose. So, in case that the company law tribunal, on the application of the official liquidator or the company liquidator, or any creditor or contributory of the company may, if it thinks fit, proper, so to do, declare that any person who is or has been a director, manager, or officer of the company, or any person who were knowingly parties to the carrying on of the business in the manner aforesaid shall be personally responsible without any limitation of liability for all or any of the debts or other liabilities of the company as the tribunal or the company law tribunal may direct. And the fourth important legislative power to lifting the corporation bill of a company or a corporate house's subsidiary companies. A subsidiary company has a separate legal entity and the holding company is not held liable for its acts merely because the holding company is the creator and controller of the subsidiary company. However, in view of the majority of members of the holding company controlling the affairs of the subsidiary company, such of the persons who control the affairs of the subsidiary company are held liable or the acts of the latter. So, in this lecture, as already we have discussed what exactly means corporation bill and how corporation bill is lifted. And in that connection, the most important first ever English leading case that we have already discussed. This very judgment delivered in 1897 by the Court of Appeal in Solomon versus Solomon and Company. So, in another important leading case, Lee versus Lee's Air Farming Limited by the Court of Appeal in the year 1961. And when it is regarding the very lifting of corporation bill under two heads, we had already discussed the very lifting of the corporation bill of a corporate house or the company by the court or the judiciary. In that connection, already we have discussed the very determination of character of a company and lifting of the corporation bill in that very important leading case. And that is an English important leading case, that is Daimler Company Limited versus Continental Tire and Rubber Company Limited 1916. And also regarding evasion of income tax. And in that connection, how the court could lift the corporation bill of a corporate house on the ground of evasion of income tax. So also, fraud by the company on the shareholders committed by that very company or corporate house, where the court has the power to lift the corporation bill, and that is the legal personality of the corporation or the company. And on the fourth ground, where the court has the power to lift the corporation bill on the ground of criminal liability of corporations. And in the second section, already we have discussed lifting of corporation bill of a corporate house or corporations by the legislatures, and that is through reduction of membership in regard to any corporation or company and any fraudulent conduct committed by the corporate house or corporation in regards to conducting a business. And also, the third one, of lifting the corporation bill of the corporate houses and corporations by legislatures in regards to subsidiary companies. So, almost in this lecture, we have in length discussed what exactly corporation bill means and how it could be lifted either by the court or the judiciary or by the legislature. And in that context, almost we have discussed the most important leading case, that is Daimler Company Limited versus Continental Tire and Rubber Company Limited, and which was decided by the Court of Appeal in 1916. So, in this lecture, we have completed another important concept and aspect associated with the corporate law or companies law.